So this is a quick overview of the entire process, from initial claim to any appeals you have to file. If you need detail about any topic mentioned, look for the related blog or video on our website or YouTube channel. So, Robert, who is eligible for VA disability benefits?
That's a good question, Brad, and I'd like to pause here for a moment. First, anyone with a service-connected disability. And what that means is you need a currently diagnosed disability, an in-service injury or illness, and a medical nexus, which is a fancy way of saying a connection between the current disability and the in-service event or injury. An example of proving a nexus is a doctor's letter that explicitly makes that connection between your disability and your in-service injury. So what we've just described is commonly known as direct service connection. Brad, what other factors to consider with service connection?
Well, Robert, one of the things you want to consider are presumptions. And that's where Congress has identified certain places and times where service members are likely to have been exposed to toxins like Agent Orange. So if you meet these criteria, it's much easier to prove service connection. Another thing to consider is secondary service connection, which is when one service-connected disability leads to another condition, like your hypertension causing sleep apnea. So even medical and medicine side effects can be considered secondary service connection.
So let's pause here for a moment because I think that's really important. So if I have to take a certain medication and that leads to other complications, I could theoretically, as a veteran, get service connected for those secondary problems from the medicine.
That's absolutely right. If you're taking a medicine to deal with one of your currently service-connected conditions, like let's say your medicine for hypertension, if that causes another problem, you can get that service connected too because it's all traced back to your service.
What are potential VA disability benefits for a veteran and with a service-connected disability?
Well, the big one is monthly compensation, which is based loosely on loss of earning potential. We'll get to how that is calculated later.
Can you also get additional compensation if you have dependents?
Yes, you absolutely can. So if you have children, if you have a spouse or others that you're supporting, you can get these supporting dependent benefits.
And obviously, you can get veterans health care as well.
That's right, and that's very important because VA does have the largest integrated healthcare system in the United States.
And my understanding is generally the worse your condition is, that is the higher its service-connected disability, if say a 50% or a 70% rating, the more medical care you're potentially entitled to.
That's right, both the more medical care and the higher rate of monthly compensation. And it's all based on the VA's rating schedule, which determines the amount of money that you're due depending on how bad your disability is.
So another thing that veterans are entitled to are VR&E programs, which are vocational rehabilitation and educational programs. So if a veteran has a disability and it prevents them from doing work they used to do, they can theoretically get retrained through the VA.
That's right. That's a great potential benefit. And also, depending on your specific disability or your rating for that disability, you can qualify for things like a clothing allowance, adaptive housing, nursing homes, dental care, and more.
And depending on the severity of your disabilities, there are also numerous benefits for your dependents. So there's dependent health care, dependent educational benefits, survivor benefits from compensation to burial fees. But before you file your claim, you need to collect a list of the evidence that will prove your claim. And so what tips can we give veterans at this stage to help prove their claims?
So one of the great things you can use is our free CCK VA Claim Builder online tool to figure out what potential claims you might have and what evidence that you can consider. It'll help walk you through that by answering a series of questions. And once you send that claim in, once you've used that tool, once you've submitted your claim, VA has a duty to assist, which it means that if you mention evidence that VA has access to, like service medical records or VA medical records or other governmental records, then it is required to help you obtain them.
And so this is really important, this duty to assist, and it has evolved over the years, and it's become more veteran friendly. than it was, say, 20 years ago. And the other thing that's really important about the duty to assist is that many times the VA is required to give you an examination to see if you're service connected, to see if your disability is related to your service so that it can become a service connected disability. And I think that's really important for veterans to understand.
So all that being said, VA does have a duty to assist, and it's their obligation to help you establish the elements of your claim. But any evidence that you know you have, you should give them, because VA also has a duty to give you the benefit of the doubt. And it's a very unique part of the American legal system, because if your evidence makes it at least as likely as not, or that the evidence is approximate balance, then your claim is true, then VA should decide the case for you.
And that's a very generous evidentiary standard, to use the legal term. Intent to file. If you think it will take a while to collect your evidence, you should still file what's called an intent to file with the VA. That way, you'll set your effective date or your start date, which is where your back pay or your disability benefits would begin from once your claim is approved.
All that's correct. And so let's start talking about actually filing your claim. We're going to pick that up with part 2.
Something that has been important to us since our founding 25 years ago has been providing free information about veterans law to veterans, dependents, lawmakers, and fellow advocates. We have over 2,000 pages of blogs and resources on our website and 800 videos on our YouTube channel, plus free calculators and other tools to help you plan your claims and calculate your compensation. Please check them out. In part 1, we talked about what VA disability compensation is. Now let's talk about how to actually get it. So Brad, how do you actually file a claim?
Well, there's a number of different ways you can file a claim. One is online via the VA's website. Another way is by mail. You can find the contact info on the VA website for the address to mail in your claim. Via a VA-accredited representative, including VSOs or accredited attorneys like CCK Law or agents. And so those are the different ways you can submit a claim. But what happens after you file your claim?
Your claim will pass through several stages while VA collects and reviews your evidence and makes a decision. You can check your status online or with your VA-accredited representative. Now, one of the things you have to be prepared for is what's called a C&P exam. And C&P means a compensation and pension examination. And the VA may ask you for more information at some point, which can move the process back a stage or two. Eventually, they'll make a decision on your claim. And generally, what's the wait time right now?
So for an initial claim, you can usually expect to wait anywhere from 120 to, I would say, 220 days. It's not uncommon to wait several months for even a basic claim. However, if your claim is approved, you do get back pay, meaning they'll pay you from the date that you filed your claim or your intent to file. And you can calculate this back pay using the calculator at ccklaw.com. And again, that's for an initial claim that you're filing.
All right. So, now the veteran has received a decision letter. What does that actually inform the veteran or the dependent who the decision is for?
So, Robert, if their claim was approved, they'll be giving a rating. And now what that means is a rating or a disability rating, they correspond to predetermined compensation up to 100% disabled or total disability. To make a long story short, the higher the rating, the higher your monthly compensation.
Are there other benefits besides compensation that start at different levels, for example?
Yes, there are, because even 0% or non-compensable ratings can open you up to VA healthcare, etc. When you hit 30%, it opens it up to dependents. When you hit 50% ratings, you open it up to Priority 1 healthcare. 60 to 7% ratings, you're then eligible for a scheduler, what they call a scheduler, total disability due to individual unemployability. And once you're at 100% or totally disabled, you're eligible for dependent education and other ancillary benefits that the VA offers.
So dependent education, let's pause here for a moment because that's a very big benefit because it helps pay for college for a dependent child, for example, right?
Absolutely. And the idea is that they want to make sure that if you are 100% disabled due to your service, that your dependents are taken care of in a number of different ways, in this case, by paying for their education at college.
So, Brad, one of the other things that has occurred more in the more recent wars is that people have suffered catastrophic injuries in battle. And sometimes they'll lose a limb or 2 limbs or 3 limbs. Is there any kind of special compensation for those veterans in addition to sort of the monthly benefit that we've been talking about?
There is, and it's something that folks don't always think about. There's the ability to get what they call special monthly compensation on top of your regular compensation, but it's only in certain situations. So here are some examples. You have a loss or loss of use of a limb or an organ. You require aid in attendance, which is the help of another person for some of your activities of daily living. You are completely housebound. And then there are a number of other examples of that. But the bottom line is there are benefits, there is compensation available beyond the 100% rate. And if you are truly fundamentally and traumatically disabled, VA's obligation is to compensate you and take care of you for those disabilities and those injuries.
There's one other benefit I want to talk about here, and it's a benefit that, frankly, VA has had a lot of problems implementing, and that's the caregiver benefit. And the caregiver benefit, as I understand it, is with a veteran who is severely disabled and really needs a caregiver to support them. That caregiver is now entitled to monthly compensation. Is that correct?
That is correct. It's a great program that was created by Congress. Unfortunately, VA's had some challenges in implementing it, I would say, but there is an additional payment, and it's in a separate program that you absolutely should file for if you have a caregiver taking care of a traumatically disabled veteran.
So let's go back to once a veteran gets a decision and they receive a notification letter or decision letter, and it's really the first time a veteran realizes, hey, maybe the VA didn't give me everything I thought I was entitled to. And so what are some of the common mistakes that VA makes?
You're absolutely right, Robert. We see this all the time. Some of the common mistakes VA makes are they get the effective date wrong, meaning that your claim, what they're paying you for, doesn't go back to the correct date, be it your date of claim, the date you got out of service, the date this disability started affecting you greatly. Another issue we see is that the rating is too low, that your disability is much more severe than VA is giving you compensation for, and so your rating should be higher. We see sometimes bad compensation and pension examinations, meaning that perhaps the doctor or clinician that did the examination went too quickly or was not fully aware of the veteran's medical and service history. We see issues with the VA's duty to assist, where there were additional records or evidence that VA was supposed to gather to inform the claim, and they didn't get it. And a lot of times, the VA overlooks uncommon or difficult to show benefits that VA should be able to see, even if they're not always directly claimed, like total disability due to unemployability, meaning you can't work due to your service-connected disabilities. We just talked about special monthly compensation, the stuff that's beyond 100%, and some of the mental health disabilities, because there are many names for the same cluster of symptoms, and sometimes VA just misses that part. You said that, well, I'm applying for PTSD, where clinically what you have is, let's say, a severe depression due to your service, and they ignore the severe depression because you said you were diagnosed with PTSD.
So it sounds like there are a lot of potential things that veterans need to be aware of in reading a decision. And what are their options if VA makes a mistake? How do you correct it? How do you appeal it?
Well, before we get into what those options are or how to appeal, I just want to again emphasize how complicated this can be, both for the veteran, the claimant, and for VA. As you see, there's tons of various mistakes that can be made. This is a complex, complicated system, and mistakes happen. So if a mistake does happen and you need to appeal, you want to keep in mind the deadline to file an appeal, and you have several potential tracks. Now, the deadline to file an appeal in most compensation cases is 1 year from the date of the decision. So these several tracks that you can potentially appeal on are the higher level review lane, the supplemental claim lane, or the notice of disagreement lane.
Wait, I have 3 separate options to appeal?
Yes.
Okay.
Yes, you do. And so there's a lot of choices that you have, and you want to make sure you make informed choices. So we won't get into these here, but there are pros and cons to each, from how fast they are to whether you can actually introduce new evidence. It's complicated.
So maybe you should consider working with CCK Law. Appeals can be difficult or time-consuming. Let's wrap up with a look at a few questions that veterans have sent to us.
So Robert, one of the first questions are, am I eligible to file a VA disability claim? What conditions are eligible? How disabled do I need to be?
So the short answer is, if something happened to you in service that causes a current disability, and a doctor relates what happened to you in service to that current disability, you're probably going to get service connected in most conditions, unless it's like a congenital condition, because congenital conditions have theoretically lasted your whole life. However, if a congenital condition is aggravated by service, then you can get disability benefits for that. And what's unique about the VA system is it covers you 24/7, the entire time you are on active duty. So if you were playing football, for example, and you got injured in a football game and hurt your knee, you could get disability compensation for that. It doesn't actually have to be in, say, combat, for example.
So the VA system is more than just combat or in the line of duty and what people think of in the movies. It's also really a workers' compensation plan for anyone who's serving their country.
Correct.
Okay. So let's go to another question, and that is, can I file a claim for a pre-existing condition that was worsened due to my service?
Yeah, and so a pre-existing condition is one that you went into the service with, and yes, if your service aggravated that condition, VA will compensate you for the part that was aggravated by your service.
So if I had a knee that was bothering me, Robert, when I went into service, they said, well, it's not bad enough to keep you from being inducted in. I had a knee, and it got worse during service because of all the marching, all the training. Maybe I was jumping out of airplanes for the paratroopers. If that got worse, I can get compensated for that?
You absolutely can get compensated for that, yes.
What are the most common forms of evidence that I'm going to need to file a claim? And does VA actually help me find this evidence with the VA duty to assist?
They do help you find the evidence. Generally speaking, you want your service records. That's critical. The second thing is any medical treatment records you have, either with the VA or through private doctors. Sometimes you may want to get a lay evidence, which is a fancy way of saying a statement from a friend who was serving with you that might be able to say, I was with John when this particular incident happened, or to describe the symptoms you're experiencing of your condition, like a family member or spouse could do that. Those are the kinds of evidence that you should gather and ask VA to gather as well.
So generally speaking, VA should be able to access my governmental records, like my military records, my VA records, maybe my Social Security records, but they may not have access, and I might have to help them get private treatment and obviously submitting statements from my friends, etc.
Exactly. That's exactly how it should go.
Okay. Well, how long does it take for a VA claim to typically be decided?
Well, there's the answer to when you first file your initial claim. Generally speaking, VA is trying to make a decision within 125 days. The reality right now is it's probably more like 145 to 150 days. The challenge is if you don't get everything in that first decision and then you have that 1 year to appeal, those claims on appeal are going to take a lot longer right now.
So about how long would you estimate that to be? Robert, on
So,
appeal?
on appeal, there's 3 different lanes we talked about. In the supplemental claim lane, it's probably 3 months. In the higher level review, it looks like it's taking anywhere from 6 months to a year. And if you file a notice of disagreement to the board, right now it's taking anywhere from 3 to 5 years, depending on which lane you choose at the board.
Wow, Robert, that's a tremendous amount of time to have to wait for an answer on your VA benefits. Why would anyone ever want to appeal to the Board of Veterans' Appeals?
Because with complicated claims in particular, you have to go to the board because that's the first time you're really going to have an attorney look at the case from the VA perspective. And so veterans law judges are all attorneys. They're trained better. They know the law better. And you have a much better chance of success at the board with those more complicated claims. But look, the reality is we'll try and appeal at the supplemental claim lane, at the higher level review. And if we can't win at those 2 levels, then your only option is really to go to the board to get a decision.
So that's kind of where you go as a last resort, where VA's really not getting it, and you think that the only way they're going to get it is to send it up to these judges and these attorneys at the Board of Veterans' Appeals.
Absolutely.
Okay. Would you like to ask a question, Robert?
Yeah. And this is a really important question. Can VA take my benefits away? So let's suppose I'm getting money and I'm getting, say, a TDIU rating 100%. Can VA take that away?
Well, like many answers in the legal world, it depends. The answer is yes, they can, because VA can schedule periodic examinations if it thinks your condition will improve. If it's not what they call static or permanent, then they can potentially get these examinations and find that it's improved. However, you're less likely to have this happen if you are given a permanent rating, or what is the holy grail for many benefits claimants, that is the permanent and total rating. The idea of the system is it is to compensate you for your disabilities and how they affect your day-to-day life. So if your disabilities really improve, the idea is, hey, you don't need that money in the same way. But if they don't improve or they get worse, you're either entitled to what you've been getting or even more. So you do get some protections over time. So if you have a disability at a particular rating at 5, 10, and 20 years, there are different protections that prevent VA from just taking that away. But there is, unless you have a permanent and total rating, that is permanent 100% rating, there is always a risk of VA taking those benefits away potentially.
You know, many people serve in the National Guard. And one of the questions that comes up is, if you're injured, how do you get benefits if you're in the National Guard?
Well, the National Guard and the Reserves, they operate a little bit differently in the sense of the entire VA system is designed to be when you were under active service. And so if you're in the Reserves and you're under active service, all the general VA rules apply. Same thing with the National Guard. Now, as we know, if you're in the Reserves or National Guard, you spend a lot of time in service, but not in what they call active duty status. There is what they call active duty for training, which is a very specific characterization of your service, and inactive duty for training. And the active duty for training is very similar to active duty in terms of the presumptions and everything else you'll get under the regular system. However, inactive duty for training has a very narrow definition of how you can become disabled. And if you're not in any of those statuses, and let's say you're in the National Guard and you were activated by your governor and not by the president, then you may not be eligible for benefits if you were injured or something happened to you during that time. It gets very complicated. So again, unless you were under federal command in the National Guard, it can be very complicated to get you those VA benefits.
All right, I want to pause here because I think this is really important. But if you're in National Guard and you get called up for active service, say overseas, and then during that period when you're overseas, you're clearly eligible at that point.
100%. We saw it very often in the post 9/11 conflicts in Iraq and Afghanistan. National Guard units were often called up into active duty service in those countries for, let's say, a year at a time, and they were on active duty. And if you served like that, you were absolutely eligible for anything that happened to you, including any presumptions of being exposed to toxic agents you're eligible.
What about Coast Guard?
The Coast Guard is eligible for VA benefits. There are some caveats there depending on when you were in the Coast Guard, but all the current members of the Coast Guard are eligible for VA benefits.
And people now in the Space Force, and I'm not joking about this, the Space Force are now eligible as well.
100%. The Space Force was something carved out of the Air Force, and the Air Force has always been eligible, and so therefore the Space Force is as well.
Okay.
What is the difference between a VA claims agent, a Veterans Service Organization officer, and a VA-accredited attorney or VA-accredited representative? I'm confused as to what these three things are.
So first of all, in order to represent someone before the VA, you have to become accredited. And what that means is if you're an attorney, you have one process. You can also be accredited as what's called a claims agent. And in that case, you have to study and take a test, pass the test. And whether you're an attorney or an agent who becomes accredited, they do a background check on you. Now, there are a number of veteran service organizations like the Disabled American Veterans, the American Legion, the Paralyzed Veterans of America. And a lot of these were congressionally chartered organizations. And they have a special accreditation procedure that they go through for their members. Any one of these can represent you, whether it's a VSO, an accredited claims attorney, or an accredited agent before the VA, and they have the skill and knowledge to represent you before the VA.
So the key point here is accreditation. Is that correct, Robert? All of these folks are accredited or, let's say, approved by VA to help you with your claims.
That is correct.
Okay.
And they have to follow certain procedures that the VA honestly watches and monitors to make sure they're doing a good job.
So this gets into the issue of accountability because the VA is tracking and allowing them to practice. And so therefore they can be held accountable if they're not living up to their obligations. Is that right?
Absolutely true. Yes.
Okay. So what is TDIU or IU or the inability to work due to my service-connected disabilities?
Okay. So let's suppose you have less than 100% rating. Let's start with a 60% combined rating or 70% rating. You're eligible for 100% rating if your singular disability at 60% or combined disabilities at 70% prevent you from working. So let me give you an example. Let's suppose you have a service-connected post-traumatic stress disorder. And let's say you're rated at 50% for that. And let's suppose you have a back condition as well. And let's suppose you're rated at 60% for that. That doesn't get you under the VA math to 100% rating. But if those two conditions combined prevent you from working, then you're eligible for total disability based upon individual unemployability, which jumps your rating to 100%.
So this gets into the fact that your rating doesn't always fully capture how much your disability interferes with your ability to maintain gainful employment or have a job.
Correct.
Okay. So TDIU or individual unemployability, it can be a life-changing and vital benefit, but it can be very challenging to prove because even VA adjudicators aren't always sure when to apply it or how to apply it correctly. So consider contacting CCK Law for a free case evaluation to see if we can help you get that benefit that you're entitled to.
Let's suppose you're getting TDIU. Can you lose your VA benefits if you start working or earn income?
So generally no, except for TDIU. Generally speaking, if you are working full-time, earning more than the poverty level, you are not going to be eligible for TDIU. However, there are some exceptions, particularly if you're in a protected workplace, and there's a few other exceptions as well that we're not going to get into.
Okay. Let's suppose I already have a rating, but I think it's too low now. And let's suppose I think it's getting worse. Should I risk my rating by asking to be re-examined by VA?
So, Robert, this is the number one question we get by potential new clients and our current clients. There's a lot of reasons to consider a follow-up claim, additional claim, or appeal. VA does make mistakes. Conditions may worsen over time, and the secondary conditions can result from your primary disability. These are all good reasons to file an additional claim or an appeal. On the other hand, you have to be aware that VA can use and does sometimes use an increased rating claim to re-examine your existing rating. So you want to make sure that you have a solid claim before filing for an increased rating, and you want to consider all these possibilities that are going on. So again, this can be a very complicated analysis. So call us for a free case evaluation if you need help.
Well, we hope you found this video helpful. If you're feeling overwhelmed, you're not alone. This can be a daunting process. And let me pause here to say the following. We've been doing this for 30 years, and it is constantly an evolving system. And by evolving system, I mean Congress changes the law, courts make decisions that change the law, and VA makes new regulations that apply to claims. So what was true 5 years ago, 3 years ago, 1 year ago, sometimes 6 months ago, is not necessarily true today.
We have hundreds of people that work at CCK Law with hundreds upon hundreds of years of experience. And this is challenging even for us because of the changes that VA is constantly implementing.
Please check out the free resources at our website. And remember, you can contact CCK Law for a free case evaluation. Don't forget to subscribe to our YouTube channel for more updates about VA and benefits. Take care, and thank you for watching.